All right. Yes, sir.
Good morning, Your Honors. Brian Mazur for the petitioner. This matter raises the question whether the appeals court decision goes against the substantial public policy enunciated by this court time and again in an unbroken chain of cases, that the law favors the finality of an arbitration decision, that judicial review of an arbitration decision is extremely limited, and that in the absence of fraud, a reviewing court is strictly bound by an arbitrator's findings of fact and legal conclusions, even if they may appear erroneous or unsupported. Now, in the appeals court decision, the school department would submit that the appeals court has given the union a second bite of the apple to which they are not entitled by law, which prejudices the department, tramples upon long-standing precedent, and would essentially allow, should it stand, a union or any party to an arbitration proceeding for that matter to get a redo when they have not fulfilled their representative obligations during the arbitration process.
Could I ask you just a question? Your claim is there's absolutely no evidence that your client was covered by civil service, right?
I represent the school department.
I'm sorry. All right. I'm still on insurance. Okay. Okay. All right. Could you tell us what's in the record on this point?
Certainly. During the arbitration proceeding, the school department submitted the collective bargaining agreement as a joint exhibit, and at the same time, the school department and the union agreed to the notice of hearing. That's page 197 of the appendix. That touches upon or shows or expresses in the last paragraph of the document that the notice would be involved or would involve Chapter 31, which is the civil service law. And if I can just turn back to the contract for one moment, I believe it's page 18 of the appendix. There's a specific language that discusses the civil service statute, and there's additional language throughout the contract that talks about civil service law in general. So,
and says that it's only, you're only covered. I understand what the contract says, but it's sort of where she fits, right? I mean,
certainly. And in addition to the notice of hearing that was an exhibit and the contract, during the hearing, which spanned a course of 10 months over 4 days of hearing, there was never any challenge from the union with respect to that evidence. They never called any witnesses to rebut the school department's submission of the issue to the arbitrator or the school department's offer of evidence that the employee was a civil service employee.
But the only evidence you've described is a notice of hearing that references Chapter 31. Is that right?
That's correct. And the school department, via the notice, had a subjective belief that the employee was covered by civil service. And the subjective belief of the school department is obviously evidence that the arbitrator could rely on to resolve a disputed fact.
Well, wait a sec. The subjective belief as testified to?
Within just the text of the document itself. The document was made an exhibit during the hearing, and under Kelly v. Rossi, and that's at 395 Mass 659, subjective belief of a party is evidence of a disputed fact.
Now, was there any record of the hearing? I gather there was no transcript, no tape recording.
No transcript, no tape recording.
So we have no clue what was said during the course of the hearing, and there's no way to find out.
No way to find out. It's uncertain. All that's certain is that in the arbitration decision itself, the arbitrator concluded that Ms. Ott, the grievant, was a civil service employee, and she referenced the fact that that issue was never disputed by the union.
And so we don't know whether or not during the course of testimony there was any reference to civil service. You just can tell us from memory, I gather.
Fair to say, Justice Gantz, fair to say.
But from your memory, was there testimony about civil service?
The hearing was, at this point, the first day of hearing was right around 6 years ago. So it's difficult for me to say that right now. No, I apologize, I'm not.
But can I understand how this How did this issue emerge? I mean, did the school department say, no, civil service employee, CBA doesn't cover? And the employee said, no, I'm not civil service, CBA does cover. So the issue was joined in some fashion?
At the outset of the arbitration, the first day of the hearing, after the parties signed their names to a sign-in sheet, the arbitrator said, okay, what are the issues that are going to be decided in this proceeding? And the school department made it an issue from the get-go that the employee was a civil service employee, she was in the wrong forum, and the grievance was not arbitrable.
So somebody said that?
Yes, I did.
You did?
Yes.
Okay, well, that's helpful.
I made it an issue from the moment that the arbitration started. The arbitrator, or excuse me, the union would not consent or agree to that being an issue, so the arbitrator piece stated, okay, since the parties cannot agree to the issues or stipulate to the issues, I will frame the issues as I see fit. And that's typical standard course and practice in an arbitration.
And how did the arbitrator then frame the issues?
The arbitrator framed the issues as, is the grievance arbitrable, number one? If the grievance is arbitrable, was the employee terminated for just cause, and if not, what shall the remedy be? And she didn't reach 2 and 3 because the arbitrator concluded that the grievance was not arbitrable because Ms. Ott was a civil service employee. And
that, I gather, is part of the record.
the arbitration decision is.
No, I
yes.
know, but even the arbitrator's
Framing
presentation
of the issues? Yes, it's in the actual decision, which is included in the appendix. So,
Right, on page 91, at the outset is the grievance arbitral. Oh, that's post-hearing brief, I'm sorry, okay.
But, and if I understand correctly, no one disagreed that she was going to frame the issues, that was with the consent of both parties, because you collectively couldn't agree on what the issues were, is that right?
there wasn't an agreement during the initial day of arbitration.
There was or was not?
There was not. And subsequent thereto, there were 3 additional days of hearing over a course of 10 months. The union never objected to the arbitrators saying, well, I'll frame the issues as I see fit. They never raised any type of issue with respect to the evidence that the school department offered that showed Ms. Ott to be a civil service employee. They never requested information of the school department over the next 10 months of hearing. They never called any witnesses. They never offered any documentation to rebut the evidence that the school department had offered. This really amounts, this entire proceeding on appeal really amounts to an untimely effort for the union to rebut the evidence when they should have done so at the arbitration.
Okay. Maybe this is the same as what you said about the notice of hearing. Something I saw was a letter. No, it isn't. It was a letter, maybe to the grievant, saying, with reference to Chapter 31, Sections 42 and 45, or
41 to 45.
41 and 45.
Yes.
Is that what you're referring to? It's
Yes, I
something-
am. Yeah,
and
page
that was
197.
and that was part of the record before the arbitrator?
Part of the record before the arbitrator. That was the notice of hearing that was given to Ms. Ott before she was even terminated. So the school department believed her to be a civil service employee, and the union was on notice via the notice that she was a civil service employee in the eyes of the school department. So that was in January of 2005, and between then and the date on which the union received a disfavorable ruling with respect to arbitrability, they never attempted to rebut any evidence offered by the department that the employee was a civil service employee. So getting back to what I was attempting to allude to or attempting to state, no, not at all, Justice Botsford. This amounts really, you have the union is essentially stating that, well, the arbitrator exceeded her authority by making a finding of fact that's not supported by any evidence. Really, there was evidence that was offered during the hearing. It was unrebutted by the union, and this is an attempt by the union to really avoid their responsibilities and that they should have fulfilled at the arbitration hearing, and they're laying the blame at the feet of the arbitrator by saying she exceeded her authority.
But what if they were right? I mean, I'm sort of losing focus here. But what if the union was absolutely right about that? Is that a kind of a question you can present on review? Isn't that an error of law that's not reviewable?
Errors of law and errors of fact are outside of the purview of a reviewing court when you're dealing with an arbitration decision. It's not like an administrative proceeding, say at the Civil Service Commission, where you can
So the evidence was insufficient?
No,
Well-
but there's an exception, right? If there's absolutely no evidence
Absolutely
at
no.
all,
All right.
then a court on review.
Okay.
And that's the claim of the union. There was zero evidence.
Yeah, that's their claim, that's their position, and that is not the case.
No, I understand your point,
Okay.
but you don't, well, maybe you do. Do you disagree with the legal proposition that if there is zero evidence, I'm not saying there is, but if there hypothetically were zero evidence of something on which the arbitrator based her decision, that would be challengeable?
No, I would disagree with that,
Oh, you
Justice
disagree with
Bosford.
that.
Yes, I would. The arbitration, or excuse me, under the cases that this court has stated and have been stated time and again, an arbitrator or judicial review of an arbitration decision is extremely limited to really in situations where the award was the result of fraud, or an arbitrator renders a decision that's in violation of public policy. If an arbitrator makes a mistake of fact or a mistake of law, or even renders a decision where there's no support in the record for the decision, the Lynn case says that a reviewing court cannot take issue with that, even if there's no support in the record for the decision.
Well, can the parties show up to an arbitration hearing, sit down and smile at the arbitrator for 5 hours, and then the arbitrator makes a decision? Is that, I mean, that's not reviewable?
Well, no, I wouldn't. I'm not suggesting that, Your Honor. But in this situation, everything turns on the fact that the union is saying there wasn't any evidence, and there clearly was evidence. There was evidence offered by the school department that went unrebutted by the union for 10-plus months. And now they're saying that there
You
wasn't.
have a two-pronged argument. A, there was evidence. B, it doesn't really matter.
Fair to say, yes.
But if they had, before the hearing, filed a declaratory judgment saying this matter is not, or if you had, that this matter is not arbitrable,
Yeah.
the court would have had jurisdiction to decide that.
Yes, and the cases cited by the union, I think, spell that out, the Suffolk County case and the Perini case. But in this situation, the union, by not objecting to the presentment of the issue of arbitrability, and then allowing the proceeding to go 10-plus months, get a disfavorable decision, and then really forum shop and come into court and say, well, it's not arbitrable, goes against the public policy of arbitration.
So your view that it is a judicial determination, but only if it is brought before the arbitration begins, and then once the arbitration begins, then the other party essentially is allowing the arbitrator to resolve it.
Yeah, they tacitly, by not stating any type of an objection, they're giving that authority to the arbitrator to review arbitrability. And arbitrators review and determine arbitrability all the time.
We'll have to leave it there,
I see that I'm
Counsel.
out of time. Thank you very much for your time.
Yes, ma'am.
Good afternoon. Karen Clemens for the American Federation of State, County, Municipal Employees. The case that you have before you is a unique case. It's a case where an arbitrator made a finding of fact, and it was a pivotal finding of fact, based on a non-fact and no evidence to support that fact.
Was this a mystery? This come out of nowhere? I'm just wondering. There's no evidence. I mean, was it a mystery that the department was claiming that she was a civil service employee?
In the opening statements and before the hearing began, where evidence is taken, there was a proposition that this case should not be before this arbitrator because it should be in civil service. The union didn't concede that fact. They said, we don't believe that this person's a civil service employee. Then the case goes on.
What happened during the case? What was the rest of the hearing all about, the other 3 days over 10 months?
The merits, the underlying merits. It wasn't bifurcated. So the arbitrator, from my understanding, I was not the attorney in the case. From my understanding, the arbitrator went on with the case and took evidence and sworn witnesses. At no time during that period did the department bring up Ms. Palmisano's, the grievance, civil service status. They were the ones with the burden in that matter.
Do you agree that if an arbitrator makes a decision that's totally arbitrary and capricious, so long as there's no fraud, we can't review the arbitrator's decision?
I don't agree with that. I don't agree with that. I believe that in Concerns Minority of Worcester, this court looked at the case where when the pivotal fact is based on a non-fact and there was nothing in the record to support it, And I agree that it's a unique circumstance. It's not very often. That case was heard in '84, and I don't think there's been a case before you since where there's a non-fact.
How do we, without a record, how can we decide that there was no evidence whatsoever?
Well, in the Superior Court, we provided affidavits from the people that were at the hearing, and those are in the record appendix.
You sort of need a record of the hearing, don't you?
Well, and asked in Superior Court, my brother who presided was the attorney for the hearing. He himself said that all that was in evidence, that he had no recollection, he couldn't put in an affidavit of any other information. All that was in evidence was a collective bargaining agreement.
Well, and you have it. Do you agree that this notice of hearing with the reference to Chapter 31, Sections 41 and 45 was in the record?
I agree with that was in the record, but that does convey civil service status on an individual. And the arbitrator didn't even put it in her fact section. She just said it was unrefuted, undisputed by the union. When the case was heard and evidence was being taken, the union would have no reason to bring up the civil service status of
But you knew that
grievance.
I mean, you knew from the opening statements that the school department was taking the position that she was a member of, she was covered by civil service.
And until they put that information into evidence, we would have no reason to refute it. That the case goes on, and as far as we were concerned, they would abandon the argument. Not even in the brief of the union did we deal with the arbitrability issue, because it became a non-issue when no facts were put in dispute.
Then when the judge made his or her decision, you didn't go back and ask for reconsideration?
Again, I was not counsel for that process. However, AAA, according to AAA, the hearing is closed once the briefs are in. There's a rule, it's a AAA case, so there's a rule that
But
once...
if you're right, does that mean then that every time an arbitration occurs, a judge has to determine whether or not there was evidence to support each finding?
No, I don't agree with that, except for the fact that this is a unique case where the sole fact relied on in this matter turns the case.
Well, you said that, but I mean, there are a lot of cases in which there may be an important fact on which the case may rest, and if you're saying now the judge has to evaluate the evidence and determine whether or not there is evidence, in the absence of any transcribed record, how is a judge supposed to do that?
Well, I would say that the First Circuit had done that in the electrical case in 1974, where that case, the decision of the arbitrator was based on, they reinstated an individual who had been terminated because the employer hadn't suspended him first. On looking at the case, they realized that the court looked at the case on the record and said, well, in fact, they did suspend him, so we should overturn that case because his sole decision was based on a non-fact. And that's what you have here. The entire decision that's before you is based on a non-fact. Ms. Palmisano does not have civil service status as a cafeteria worker, as a cafeteria manager. She could not have gone to civil service and had her case heard. She would have been provisionally appointed, and as a provisional appointment, she would not have had those rights.
Do you agree that your opponents at least argued that she was governed by civil service?
They may have argued, but they didn't provide any evidence for the arbitrator to make a determination.
Do you agree that the arbitrator took the position that they would resolve that point, that they would resolve that issue?
I agree.
It had been raised, and the arbitrator said, I'll resolve that in my decision?
The arbitrator didn't necessarily say they would resolve the fact of whether she was civil service or not. The arbitrator agreed to resolve the language in the contract of whether it meant that because she had civil service status, whether she could be in arbitration as well. I don't necessarily agree with the arbitrator's finding in that matter. However, I appreciate the fact that she looked at the collective bargaining agreement, there was evidence before her, and it was her reasoning. I'm not questioning the arbitrator's reasoning in the matter before you. It's the fact that she took a fact that she had nothing to support that fact. And even in her brief, she writes, that the union didn't defend it. It doesn't make it true. The union had no burden to defend a fact that wasn't put before them. On a second note, I would suggest that the arbitrator did not have jurisdiction to determine her own jurisdiction, that it was an issue of substantive arbitrability, and the arbitrator should never have made the determination to begin with. And I don't know of any statute or case law that requires the union to only bring up this issue prior to a case being heard.
So your view is that you can litigate before the arbitrator, lose, and then have a de novo determination by a court after the fact?
Well, it's, I think that my brother in this case knows that, or should have known, that substantive arbitrability issues are for the court.
So the answer to my question is yes, you think you are entitled to have the matter be resolved by an arbitrator, and then if you lose there, to have it resolved again by a court de novo.
I don't believe that the arbitrator has the jurisdiction to determine her own jurisdiction, so yes.
But you didn't challenge it then. When the arbitrator said, I plan to decide that issue, you didn't say, wait, I'm not going to let that matter be decided by you. I'm going to, you didn't challenge then the ability of the arbitrator to make that decision.
I believe, and again, I was not there, I believe that it was challenged about the arbitrability, and the parties agreed to allow the arbitrator to frame the issue, which is common. But it's not what usually happens, is you don't know what the issues they frame until they write their brief.
In this case, the collective bargaining agreement has language in it, I'm forgetting whether it's Article 5 or whatever it is, that talks about parties who aren't covered by civil service can grieve through the collective bargaining agreement, but those who are can't, right?
Correct.
So wouldn't a question about whether that language, how that language applies to this case, wouldn't that be an arbitrable question? In other words, the facts of this case? Which side of that language this particular grievance falls on? Wouldn't that be an arbitrable point?
Well, I don't believe it's as clear as you stated it, that if you're covered under a statute, you can only go through the remedies of that statute. So I think it's a jurisdictional issue as to whether the arbitrator had the right to hear the matter. I don't necessarily, again, as I say, I don't necessarily agree with the arbitrator's interpretation of their own jurisdiction in that matter. If there's nothing else, I rest on my brief.
Thank you very much.